So the Emergencies Act, is that a big win for freedom or more than it's cracked up to be? Let's take a look. As I'm sure you've all heard by now, a few days ago, a federal court handed down a ruling in regards to the use of the Emergencies Act against the 2022 Freedom Convoy. And in what is actually a surprise to me, handed down a favorable ruling. It was ruled unreasonable, ultra vires, and unconstitutional. This particular video, we're actually not going to be diving too hard into the document. It's going to be more my opinions on what I do and do not like about the ruling, and about the particular rationales used in this case. The document itself can be quite intimidating for most people. It is 190 pages long, and it is jam-packed and full of legal jargon. That being said, if you guys want to read this for yourself, it's actually not as intimidating as it looks. It is fairly straightforward if you read the right areas. So if you want to read this and understand it for yourself, I recommend starting with the legal framework, which takes you to paragraphs 100 to 102. That's worth reading. That kind of sets the stage and really tells you exactly what the court is trying to decide. And then from there, if you start at page 65 on the substantive issues, and that's basically them trying to establish what questions they need to answer based on what they're looking at, as well as them answering those questions. So from page 65 on the substantive issues down to the conclusion on page 123, that's only about 60 pages. That's still quite a bit, and it's still very wordy in there, but it's not the intimidating behemoth that a 190-page legal document is. And especially during this section, during these 60 or so pages, the court actually does a pretty good job of dumbing it down. Not that they're trying to do that. They still do quote a lot of precedent and stuff in there, but they also explain what is in that precedent, so it's not like you have to come in with any sort of prior knowledge. You can basically just read it start to finish to see exactly what happened. But if you want to dumb that down even further, all you really need to look at is the analysis and conclusion parts here, because most of the rest of that is also the court acknowledging the various arguments that the applicants or the respondents made. But we're not going to go too hard into this. I just want to go over a couple of quick lines and really explain the ruling and the reasons why the judge made the ruling. And then we'll get into my take on it from there. If you are looking for more of a deep dive, the Canadian Constitution Foundation, the CCF, has a YouTube channel, and they were actually one of the applicants in this case. They actually went before the judge to make this case. They have a 20-minute review on the case. They kind of break it down into 10 points and simplify those rulings for you. I haven't seen anything from Runkle of the Bailey yet. He's also a pretty popular YouTube lawyer, and this would be right up his alley. I imagine he's going to do a video like this at some point in the near future, in the next couple of days maybe. So keep an eye out for that as well. And most of what this case comes down to, ultimately, is definitions. Two definitions in particular. One, it says a national emergency can only be found to exist if the situation, quote, cannot be effectively dealt with under any other law of Canada. And that's very important, because if it could be dealt with by another law in Canada, you don't need the Emergencies Act. The Emergencies Act is designed as a tool of last resort. Now, and that is stated many times throughout this court ruling, is that it must be a use of last resort. And then secondly, here it says, under the Act, for a public order emergency to be declared, there is the additional requirement that there must be a threat to the security of Canada. Now, this definition is taken directly from the CSIS Act, Section 2 of the CSIS Act, and that definition is very specific. Here it says, activities which are directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving political, religious, or ideological objectives. And the court itself, Justice Mosley, who's the judge that is presiding over this case, went out of his way to embolden this particular section, the threat or use of acts of serious violence. So the legal threshold for invoking the Emergencies Act is the threat or use of serious violence, as well as the fact that it must be significant enough in scope such that it cannot be effectively dealt with under any other law of Canada. That's really the two parts. Pretty straightforward. So let's go see what he had to say about that. So it says here, a broad and flexible interpretation of the words threats to the security of Canada could encompass the concerns which led the Governing Council, the GIC, this is effectively the cabinet, to issue the Public Order Emergency Declaration, which is invoking the Emergencies Act. Had the meaning of those words not been limited by reference to another statute and applying a differential standard of review, the court would have found that the threshold was justified. However, the words threats to the security of Canada do not stand alone in the Act and must be interpreted with reference to their meaning of that term as it is defined in Section 2 of the CSIS Act. And here the judge actually defines what serious means. So what exactly is a serious threat? Here he says guidance to the meaning of a serious threat in the context of national security, which can be found in the case Suresh at paragraph 90. So here serious is defined is something that must be grounded on objectively reasonable suspicion and based on evidence, and in the sense that the threatened harm must be substantial rather than negligible, which is kind of what we all think of when we hear the word serious. It's got to be substantial. It's got to be very serious. And then here in paragraph 287, it says the court may share the views of those who think that a definition designed to constrain the investigative actions of the security service is ill-suited to serve as a threshold for the invocation of the emergency powers by cabinet, particularly when there may be other valid reasons for declaring an emergency, such as those set out for in the proclamation in Section 58, and those are the reasons that the government actually officially stated for invoking the Emergencies Act. However, and this is very important, but the court cannot rewrite the statute and has to take the definition as it reads. That's super important. You can't just make up new laws, and you can't just make up new interpretations of the current existing laws. The court has to take it as it stands, exactly what it says. And ultimately what it boils down to is this. The Section 58 explanation states that violent incidents and threats of violence and arrests related to the protests have been reported across Canada. However, these reports were vague and unspecified, apart from allegations that tow truck drivers in Ottawa had been threatened should they assist the police. What that meant is unclear. The only specific example of threats of serious violence, which is provided, happened in Coutts. Arrests related to the protests may have amounted to evidence of activities directed towards or in support of the threat of use of acts of serious violence against persons or property, but the arrests, aside from those at Coutts, appear to have all been for minor offenses. There had yet to be any actual serious violence of threats other than in Coutts when the decision was made, and the Prime Minister even specifically acknowledged this during the public inquiry under Rouleau. The judge then went on to say that while all these events are concerning, the record does not support a conclusion that the convoy had created a critical, urgent, and temporary situation that was national in scope and could not be effectively dealt with under any law in Canada. And remember, that is the threshold. That is what you needed in order to invoke the Emergencies Act. In short, the situation at Coutts was dealt with by the RCMP employing provisions of the Criminal Code. Which means, very objectively, this was not a threat to the security of Canada, which means it could not have been a national emergency, which means you could not have invoked the public emergency orders, which means the invocation of the Emergencies Act was ultra vires. When it came to the events in Ottawa, this is what the judge had to say. Ottawa was unique in the sense that it is clear the OPS had been unable to enforce the rule of law in the downtown core, at least in part due to the volume of protesters and vehicles, the harassment of residents, workers, and business owners in downtown Ottawa, and the general infringement of the right to the peaceful enjoyment of the public spaces there, while highly objectionable, did not amount to serious violence or threats of serious violence. That is not to say that the other grounds for invoking the Emergencies Act specified in the proclamation were not valid concerns. He then says, in his view, they would have been sufficient to meet a test of threats to the security of Canada had those words remained undefined in the statute. The harm being caused to Canada's economy, trade, and commerce was very real and concerning, but it did not constitute threats or the use of serious violence to persons or property. For these reasons, I am also satisfied that the Cabinet did not have reasonable grounds to believe that a threat to national security existed within the meanings of the Act, and the decision was ultra vires, which means it was outside the scope of the law and it was above the authority they had to invoke that Act. The ruling then does also go on to state that a number of the provisions enacted under the Emergencies Act were unconstitutional, even if they were valid to be used. But I'm not going to go into that stuff. It is enough to know that it was just unconstitutional. But if you want to see more of that, go check out the CCF's video on it. Like I said, it's about 20 minutes long. It breaks it down to 10 very easy to digest talking points. And I'll put a link in the description below so that you can go see that there. And this is the last line of his ruling. This is at the very bottom of the document. It says, I have concluded that the decision to issue the proclamation, which is the Emergencies Act, does not bear the hallmarks of reasonableness, which is justification, transparency, and intelligibility, and was not justified in relation to the relevant factual and legal constraints that were required to be taken into consideration. In my view, there can only be one reasonable interpretation of the Emergencies Act sections 3 and 17 and paragraph 2C of the CSIS Act. Those are the areas for the threshold of what a national emergency is and a threat to the security of Canada and so on. And the applicants have established that the legal constraints on the discretion of the Cabinet to declare a public order emergency were not satisfied. So the Government of Canada has already said that they intend to appeal this decision, but appeals are difficult. In order to actually successfully launch an appeal, you need to either prove that the facts of the case were wrong, which isn't really an instance here because the judge actually specifically says in the case that he's not interested in the facts because both parties broadly agreed on exactly what happened. And those facts very clearly demonstrated that there was no threshold that was met. It just wasn't there. However, you can also appeal on the judge's interpretation of laws and their interpretation of what standards they use and so on. And I think here the Liberal government actually might have some breathing room. So throughout this case, the judge made a number of comments expressing his empathy, in a way, for the difficult choices that the government had to make. And he said in a number of instances, he might have even agreed with them, had the act not been so stringent and had it not been so very specific. And this is actually a really big problem, because one of the things that government actually does have is something called deference. Earlier in the case, the judge actually did dismiss their deference, but that could be something he interpreted incorrectly, and that could be something that the government could appeal. And the reason for that is during emergencies and during crisis, when you don't have the benefit of hindsight, you do have to give the government and all legislative bodies a certain degree of latitude for unintended consequences or unforeseeable futures. So you can't always just make objective rulings. And that is something the judge directly acknowledges in this case. However, he had stated reasons for why that didn't apply here, but that could be an interpretation that they could theoretically appeal. And if a higher court here does agree with that, it would be very easy for them to get an appeal on those grounds because of how much sympathy and how much agreement the judge expressed for the government in this case, which I think is unacceptable. I think that places the government as the thing of the highest value in the land, and freedom and protest for people as subjective to that or subordinate to that, to a degree and to a magnitude that I think is unacceptable. So even though today feels like a win for a lot of people, I am much less optimistic. For me, this feels kind of like one step forward, two steps back. At no point during this process, during any of the committees, any of the hearings, even the public inquiry, nobody's really asking the right questions here. Everyone's trying to find out what the government could have done differently, what more powers they need to prevent this from happening next time, and so on, and so does this court case. There are a number of places in this court case where the judge says, well, maybe we should change this, maybe we should change that, we got to give the government more powers. But at no point are there any considerations being made for freedom or for Canadians. All of the conversations are around what the government can do differently next time, and one big thing is always left out. The government could have backed down. In the past, and maybe this is revisionary history, I wasn't around for a lot of this, but throughout most of the 1900s, it was common in Western society for thousands of people, or even sometimes millions of people, to gather together in a protest and march and scream and yell and take up space and be a problem. That was common, and they were fighting for their freedoms. They were fighting for equality, whatever their particular cause was, but it was always oriented towards freedom. And as a result, not necessarily immediately, but over time, a lot of these rights were instated. The government was listening to people. The government would hear these protests and go, great, we will do the things that you want us to do. That was part of the conversation. Protest was part of the democratic process. And in this particular case, the Freedom Convoy, they had such a small ask. All they wanted was to go back to work. And this is supposed to be, in theory, something protected under the Charter of Rights and Freedoms. So this is the charter here. If we scroll down, if we take a look at the mobility rights as laid out in Canada, you have the right to pursue the gaining of a livelihood in any province. That should be a right that the charter protects, and that's all these people were asking for. That was what the Freedom Convoy want. They couldn't go to work. The provincial government was preventing them from working. That's all this was. And in response to that, rather than the government saying, okay, we've heard you, we've overstepped, we understand, we will let you go back to work, which in some sense isn't even really the government's decision to make. Instead of doing that, the Liberal government decided to take it upon themselves to create a national emergency out of what was essentially a basic protest, a protest for their rights and for their freedoms. The Liberal government poured fuel on the fire and made mountains out of molehills so that they could use the Emergencies Act instead of protecting people's rights. And perhaps most ironically, the government used serious violence against people in order to pursue their own political and ideological objectives, rather than just let people have their rights. Did that sound familiar? It should. That is what it means to be a threat to the security of Canada. A threat to the security of Canada is defined as the threat or use of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective within Canada. This wasn't religious, but absolutely this was political, and absolutely this was ideological. There's no way to deny that. All it comes down to is a matter of perspective. Do you believe that Canada is the government, or Canada is the people? For me, I think Canada is the people, which means the Liberal government is quite literally the CSIS definition of a threat to the security of Canada. Just want to let that sink in for a minute. That is how insane Canada has become. That is how insane the Emergencies Act was. And that is how insane it is to me that at no point during this process is anybody discussing that fact. Everyone is discussing how the government can get more power, how the people can have fewer rights. That's what the whole conversation is. That's what all the committees are talking about. That's what the inquiry is talking about. And that's even what this court ruling alluded to. It says here in paragraph 281 of his decision, he says, it may be that Parliament will wish to revisit the question of whether the CSIS Act definition adequately covers the different harms that may result from an emergency situation when they may fall short of serious violence to property. The court can only apply the law as it finds. It has no discretion to do otherwise. So here he's really suggesting that if the government in the future wants to crack down on protests like this, they just have to change the law, rather than saying that these laws themselves are out of line or that they really shouldn't even look at changing these laws. He's actually kind of encouraging them to do so that next time they will just have more power to clamp down. So that's something I really don't like. That really feels like the courts are on the side of the government in keeping down the people, and I'm not a big fan of that. Now, in fairness to the court, that wasn't their objective to find anything like that today, and it certainly isn't the purpose of this court to make some sort of unilateral ruling affecting the charter or freedoms or anything. That would be far beyond the scope of this case. But within the scope of this case, the court did suggest and did recommend and even accepted the possibility of giving the government more powers in the future so that people would have less rights and less freedoms so that they wouldn't have to use the Emergencies Act again. Which to me is, for me, that's insane, but hardly surprising. So what does this mean for firearms owners? Well, unfortunately, it's not good news. There isn't a whole lot in here. There isn't really anything in here regarding our rights and freedoms as firearms owners. And there certainly isn't any pro-rights or pro-freedoms rulings in here, beyond the fact that the judge really did just observe that they didn't have the power to do what they did. Not that he disagreed with them using the power, it's just that the power didn't exist. So there's no positive benefits for firearms owners as a result of this. However, what is a problem is the scandal. This is going to be maybe the biggest scandal of Justin Trudeau's career, although who knows, there's certainly been a mountain of them. But unfortunately, when times get tough for the Liberals, they look for scapegoats and they look for somewhere to deflect the story and to change attention. Something else that the media can talk about. And all too regularly in the past, that's us. That's firearms owners. So this probably means that things are going to get rough for us in the near future. And things are going to get worse before they can get better. So keep your chin up, and hopefully change can come in the near future. The good news about all of this, if there is any good news, this would certainly be grounds for a non-confidence vote. People have been talking about non-confidence votes for a while, for a year at least now, but those have largely been relegated to the sort of the fringe of the conversation. Now I feel like it could definitely be a front and center topic. If not now, then when? If this isn't grounds for a non-confidence vote, and to have him resign, and to have the Liberal Party dissolve Parliament, if not now, then when? There really isn't a better time for this than when the government violates your basic rights as they are outlined in the Charter. There is no higher betrayal and there is no higher transgression than this. If not now, then when? Personally, I'm not feeling optimistic. I think the Bloc and the NDP have far too much to lose by agreeing to such a vote. Unfortunately, everything's political. If they did hold a non-confidence vote and everybody voted yes and Parliament dissolved, the Bloc and the NDP would be effectively resigning themselves to 4 years of having no power of any kind. If Conservatives get a majority, the NDP and the Bloc will have no power for 4 years. That's not something they're interested in. They will probably wait until the polls suggest that there's the possibility of the Conservatives getting a minority government before they make any moves. So I'd like to thank everybody for watching. If you like the new digs, please hit the like button. Get subscribed. I'd actually like to hear your opinion about it. I think this will be my shtick from now on. So I'd like to hear your opinions about that in the comments down below. If you want to see more content like this, let me know. But also, please hit that subscribe. The current channel goal is to get to 1,000 subscribers. That'll allow me to join the partnership program, which means YouTube should start promoting my videos more. And that should dramatically help the view counts to get some of these messages out that I'm trying to put out there. So please hit that subscribe. It'll make such a huge difference for me, and it'll help spread the good news to everybody. But that's all for now, and we'll see you guys in the next video.